Before starting, I would like to thank the Center again for the opportunity to work and to explore further the ideas on revision of the guidelines to that report, as well as the sponsors for their support in all manners and their availability through the process. In the following, I will present you the main conclusions from the main findings of the report, starting by exploring what are the objectives of the research and by stressing the role, the central role that the guidelines play in the legal architecture of EU stated regime and in EU energy policy. And I can already say that we have had a focus on energy as such more than environmental protections through the report. It is because the EEAG plays such a central role that the revision needs careful attention. And the report analyzes and makes recommendation on the ambition level for the revision, the structure of the guidelines, what could be, what should be the guiding principles, and the need to update the sectoral coverage of them. So I will now go through those successive points. First, the objective of the report. The report examines the review process for the guidelines and its scope, focusing on the possible and necessary areas of change. As mentioned by Director Gerson, the review process has been postponed to next year, and the 2014 guidelines have been prolonged to the end of December 2021. Together with other pieces of legislation related to state aid, including the General Block Exemption Regulation. That makes 2021 a crucial year for the finalization of the revised guidelines and other pieces. The report aims to identify how the revised guidelines can contribute to fast-tracking the transition towards low carbon energy system in a cost efficient way and consistent with the internal market principles. Those are keywords and consideration that have been mentioned by Director Gerson, so I'm very pleased to that we are on the same line on that point. The report examines as well the interaction between the guidelines and stated rules, which are relevant for the energy sector. It examines the manner the Court of Justice of the EU has interpreted the definition of aid and what are the consequences of this interpretation on the use and scope of the guidelines. The report studies the impact of the newly adopted clean energy package and the European Green Deal on the revision process and again scope, raising attention on the need for consistency across those different pieces of legislation or regulation. And finally, it examines the different aid measures. I will not present all the different measures that we have reviewed in the report, but you will find a comprehensive list of them. I will just take some examples in that context. Through the process, COVID-19 happened, and of course we try to take it into account as much as possible, and we advanced some recommendations as to what it could mean in terms of criteria, application of stated regime, and the objective of common interest that could be revised. To know how to revise those guidelines, it is fundamental to understand the role played by this soft law instrument that the guidelines are. Indeed, they are binding on the European Commission. They are not binding on the member states as such, and in most cases, but they do have legal effects, and the Commission services will apply those guidelines when assessing the notified aid measures. So the member states know that they will follow them, they will bind for them. And when we're talking about the role of the guidelines, I would like to say 3 points. The first one, it is part of a compliance strategy with EU climate and energy targets. It is part of a legal ecosystem that has to be considered as a whole. And finally, it is an enabling framework. So if we look at the compliance strategy, the current guidelines intend to assist the member states in reaching their 2020 climate and energy targets and to prepare the ground for achieving the objectives set in the 2030 framework. The revised guidelines should serve the same purpose. On the one hand, compliance with climate and energy targets under the adopted 2030 framework, and climate neutrality by 2050 goal, so the future. The revision of ambition level under the European Green Deal needs to be considered too, with the proposed increase of the greenhouse gases emissions reduction targets to be enshrined in the European climate law, and the increase of renewable energy target as such. So those increases in targets, in EU targets, will need to be mirrored in the guidelines. As part of this compliance strategy, the report questions how the guidelines can contribute to the following 4 points. First one, fast-tracking decarbonization. The need to increase the speed of decarbonization was stressed by the European Environment Agency in its 2020 State of the European Environment. And the reduction curve will become steeper with the increased targets that just have been proposed. So the guidelines will be instrumental in supporting rapid and decarbonization of the whole energy system. Second, the states have an important role to play in enabling the deployment of existing and eligible measures, and at the same time stimulating further innovation. And in order to speed up decarbonization, it will be necessary to play on both, using existing technologies at large scale and deploy new ones. In that process, it may be the guidelines may need to define milestones, including a stepwise approach like it has been proposed in the hydrogen strategy. And finally, the guidelines should continue, of course, to pursue the objective of an integrated internal energy market. The revised guidelines should contribute to provide the right market signals and ensure a level playing field. And to do so, they should build on existing binding rules for energy market design, as laid down in the Clean Energy Package now. The guidelines should also, in addition, follow a holistic approach for the world energy system, as it has been stressed by the European Commission in its communication during the summer on energy system integration. That means as well, having a holistic approach to the energy system, that the guidelines should be in line with both the technology neutrality principle and the process of sector energy system integration. The second point related to the role of the guidelines relates to its place in this legal ecosystem, because there is a close link between the general block exemption regulation, the EEAG, and secondary legislation. The current guidelines build on the provisions of the GBER and complement them. Therefore, if the Commission intends to keep the same ecosystem of rules, the same logic, it is necessary to enshrine in the GBER the key principles and criteria for eligibility that the guidelines can build on. So there is a close link that is made today and that the report advised to keep in the future. So therefore, it is very important to coordinate the revision process for those different instruments. The guidelines also serve as a ground for revision of secondary legislation. This has been the case for the revision of, for example, the Renewable Energy Directive. And this is a link that also should be made when we are revising the Renewable Energy Directive or the Energy Efficiency Directive. Finally, the EEAG are an enabling framework. As reflected in the national energy and climate plans, decarbonization of the European energy system relies on different national strategies. And in respect of the principle defined in the treaty of the sovereignty over energy mix for the member states in the Treaty on Functioning of the Energy Union, the revised guidelines should enable the member states to define different decarbonization pathways across the different vectors. But the guidelines can play an important role in designing those pathways. So this is an element also of framing. Looking at now the needs for revision, it has been stressed already in the introduction by Bruno, and I can only state again that yes, the revision is moved by this compliance mechanism, this compliance dynamic related to the 2030 targets and by the 2050 goal, in addition that it should be aligned on the clean energy package. A second motivation rationale for the revision relates to the need to reflect the content of the clean energy package. So renewable energy directive, energy efficiency directive, electricity directive, they need to be mirrored in the guidelines. And we have in the report elaborated a table mapping the influence of the secondary legislation on the revision of the guidelines. So you will find that in the report. The third motivation relates to climate legislation, climate commitments. The member states are committed under the Paris Agreement in terms of targets and reporting obligation. And they have adopted national legislation related to those international commitments, and those national legislations are as well a starting point for adopting new measures, including economic regulatory measures that could fall under stated rules. As we have seen by the recent climate cases in terms of climate litigation, the states are also now legally required to increase the ambition level. So I can refer to the Urgenda case in the Netherlands, but as well the climate case Ireland during the summer, where the member states are challenged their liability and the duty of care of the state, urging them to take more ambitious initiatives in the area. So the combination of these factors will encourage national governments to adopt a series of plans and support schemes that will need, if they go over the threshold for notification, to be examined by the European Commission for the purpose of approval. Then the energy sector has gone through fundamental changes. The market fundamentals have changed, the technologies have evolved, the actors have diversified. So this needs to be reflected in the guidelines. We have a series of proposals in terms of adjustment of those sectors and new services, new markets, new products that have appeared. Finally, the recent case law by the Court of Justice of the EU has challenged the implementation of the guidelines, with decisions showing a higher intensity of the judicial review. This raises two questions for the purpose of the report: one of the general approach followed by the guidelines, and one of their implementation by both the member states and the European Commission. Fundamental question for the report at the start was, how should we envisage the structure of the guidelines? And if you remember, the efforts made at the start of the previous guideline was to emphasize the methodology for assessment of the measures with a common assessment, a list of common assessment objectives. And this has contributed to more transparency and foreseeability as well in the use and the application of the guidelines by member states and the Commission. So the report advises for keeping such an approach, but raises the question of, should we structure the guidelines in a slightly different manner? And three alternatives are discussed. One which is related to an objective-based approach, focusing on some key benefits, for example, environmental protection, climate, system adequacy, flexibility, resilience.
Sorry, Professor. Sorry, yes? Professor Banet, can you move the slide? Because I think...
Oh, sorry. Thank you. A second approach based on specific measures only, and a third one, which is a combination of the two first. And the report concludes in favor of the combined approach, combining common objectives and specific measures. Different elements are to be considered for choosing the approach. the architecture of the legal regime on state aid, the margin of appreciation left to the member states, the application of notably the proportionality test, the flexibility in the dialogue between the member states and the Commission services, the need to ensure level playing field between the member states if they have too large margin of appreciation that may create some huge differences between the member states. And finally, and again, the question of judicial review, because if the criteria, the assessment criteria in the guidelines are not precise enough, this may raise a risk of seeing the approval decision challenged by the Court of Justice, increasing the lack of legal certainty and economic risk for the beneficiaries. And the guidelines, after all, aim to contribute to legal certainty and transparency. So those are key motivations that also influence the choice of structure for the guidelines. And in the following, we have further elaborated in the report what could be those guiding principles and what could be this methodology, what has to be revised. So the report details comebacks to the common assessment principles as they are defined at the moment. And again, if you remember, in the previous revision of state aid regime, the inclusion of common assessment principles were key to develop a common approach in the revision of the state aid legislation. And the definition of common assessment principles follows that previous reliance on the balancing test, where the use of economic and financial tools to assess whether the notified aid measures could be authorized was key. This was reflected in certain criteria such as market failure, incentive effects, and proportionality that are very much discussed in the decisions and in the as well the judgment of the Court of Justice. So the emphasis put on economic analysis is obvious following that common assessment principles approach. And it is also obvious in recent notified aid measures, such as the Hinkley Point C case or the capacity mechanism decisions. And both are in the news today. So you may have noticed that the appeal judgment in the Hinkley Point C has been released this morning, and the Commission has launched an in-depth investigation in the Belgian capacity market. In addition to this list of common assessment criteria, which are defined in the guidelines and that the report review, there is also some key criteria that should be emphasized. Those are related to technology neutrality, eligible cost, and stability of the schemes. Mainly, I would like to comment on technology neutrality, which is referred to in the guidelines. It is referred to much more indirectly in the Renewable Energy Directive. It is referred to in other directives, but it should be emphasized, again, because we need to ensure a level playing field. We need a deep, rapid decarbonization, mobilizing all technologies. But in accordance with that combined approach, it should be accompanied by a benchmark on the common objectives. And therefore, it will be fundamental as well to reflect and revise the definition of the common, of the objectives of common interest in the view of this benchmark exercise. Put here the example of the support mechanism for renewables, in particular electricity production. This is a good example. The approach concerning eligible costs is also something that needs to be reviewed, notably in relation to energy infrastructures, stability of the scheme. We have a series of arbitration cases that have triggered the revision, retroactive revision of the support schemes. This has been addressed in the Renewable Energy Directive, Article 6, but it should be further emphasized, also providing for visibility and accordance to the rule of limiting the period of validity of the scheme. Usually it's 10 years. To sum up, The report recommends to keep the alignment with the 2030 climate and energy targets and 2050 goals. In terms of methodology, the report recommends a combined approach between common objective and specific aid measures, and the reports provide for a systematic review of the key specific aid measures. There is a need for clear assessment criteria, guiding principles, and a revision of the objectives of common interest. The material scope of application of the guidelines must be reviewed, and finally, attention should be paid to enforcement to avoid any negative decision from the Court of Justice. Beyond the report, we couldn't cover everything, and there are 2 points that I would like to further emphasize, going beyond the scope of the report. The first one is related to consistency. There is defined in the treaties a duty of consistency in Article 7 of the Treaty on the Functioning of the European Union, which also involves duties for the EU institutions to reach that, to comply with that duty. And because we are facing a high level of regulatory changes in the year to come, and Maximo called that itself a regulatory tsunami, which I think is a good picture, we need to make sure that those different instruments, including financing instruments, will be consistent between each other. Many common definition, common objective, common benchmark lines. Second, the guidelines are part of this green economic recovery post-COVID-19. And there are different questions that need to be addressed. What kind of requirements can be set when examining the aid measures? Director Gerson also talked about bonus. That could be one option. Resilience is clearly a consideration to be addressed. So how can this be defined as an assessment criterion? And finally, in terms of industrial policy, how far can the guidelines go in supporting the recovery of the European economy? And should we associate some safeguards as well to avoid protectionism to those more pro-industrial measures?